Raphael is currently working at the I Courts at the University of Copenhagen, and she is also lecturer in European Union law at the Edinburgh Law School. Now, if we have Raphael here, which I hope she is. Yes, she is here.
Hi.
So, yes, Raphael, sorry to interrupt you for a minute. You have 25 to 30 minutes to do your presentation. Is this okay?
That's fine.
Okay,
That's
so
fine. Yeah,
I leave the floor to you.
The only thing is that I cannot share my slides because I haven't been made a presenter, I think. Okay, someone is sharing them for me. That's brilliant. Should I then signal to you when you should switch? Okay, great. Thank you so much. So good morning, everyone, and thank you for making me part of this brilliant program. Thanks to the organizing team and in particular to Alba. So today I will focus on the topic of algorithmic discrimination and European Union equality law. And the way I will do so is that I will talk about the problem and what is algorithmic bias, give you some examples to make it more concrete, and speak to the origins and causes of algorithmic discrimination. Then I will talk about the law and in particular the gaps in the scope and in the way EU anti-discrimination law is organized. And then we'll talk a bit about the way forwards with EU anti-discrimination law and other legal avenues. So to start with a few concrete examples, I would like to mention maybe 3 or 4 things to just show you that algorithmic discrimination is a problem that affects all of us in a very concrete, and in a very direct manner. So you've heard maybe about facial recognition, for instance. So these algorithms have been shown to recognize white male faces much better than dark male faces. And so this can be problematic for a number of ways in and of itself, but also because these facial recognition algorithms are used to maybe grant access to certain places or certain services. So you can see how that affects us in a very direct way. Then another example is the prototype that Amazon had developed in, I think it was 2014. They had developed a machine learning algorithm that was used to automatically scan applicants' CVs and rank them according to their employability. And the fact is that that algorithm had to be abandoned because it systematically disadvantaged women and eliminated women from the pool of valuable candidates. Then there's another example, which is the Apple Card, which has been in the media quite recently, so you've maybe also heard about that. The Apple Card used an algorithm once again that actually granted much higher credit limits to men than to women, and that couldn't be explained by actual credit scores. So there was clearly also a type of discrimination going on as well here. And then last example, a study was published in a scientific journal whereby scientists had simulated the distribution of a job advertisement on Facebook. And they had asked Facebook to just distribute some job ads that they had crafted in a neutral way. And the result is not at all neutral. So the study shows, for example, that in the worst cases, Facebook had distributed, for example, an ad for a cashier position at a supermarket to 85% of women, an audience that was female at 85%. But a similar job advertisement for a lumberjack position, for example, was distributed to a male audience that was 90% male. So you can see again here that there's a clear bias in the distribution of that job advertisement, and that relies on stereotypes, and that also reflects structural forms of discrimination, such as gender segregation in the labor market, for example. So how does that happen? Well, to understand how AI reproduces and amplifies discrimination, let's look at this slide. It symbolizes the various elements of what's called a machine learning algorithm, which is what I'm interested in mostly today. And it's a bit like a food recipe. So you have your data, and these are your ingredients. That can be the traces you left online when you browsed the website, or that can be your email contacts, that can be the last products you viewed or you bought online, etc., etc. Then you have your cooking instructions, and that's the problem design and the algorithmic model, because there are several statistical ways to modelize a problem. And then you have your dish, and that's the algorithmic output, for instance, a risk assessment or an algorithmic recommendation. What happens is that you give a computer a set of instructions, and for instance, that can be predict which 3 applicants will perform a job X best. Then you train the computer, you feed it with data so it can learn what to look for when identifying the best candidates. For example, you give it the CVs of past applicants, applicants who've been promoted in the past, for example. And then what happens is that the machine infers from that complex data set what it is that makes employees perform best, so to say. And it comes up with a recipe for success. And then you can ask the machine to apply this recipe for success to new data that you really want analyzed. So, for instance, current job applications in our example. Then the computer dissects the data, applies the recipes, and issues a recommendation. And then you might follow or not follow that recommendation. So it's clear that there are 3 channels for algorithmic discrimination in this decision-making setting, so to say. There's the data that incorporates different types of past discrimination, as everyone knows. So if social data is biased, then the output will be biased as well. For instance, in the Amazon hiring algorithm, it can be that past decisions were biased because of gender stereotypes, because women's work evaluations were systematically worse than male job evaluations, etc., etc. Then you have the algorithm themselves, which can be a channel for algorithmic discrimination because the formulation of a problem or a situation is not neutral. Whatever you want to optimize, to make calibration choices, you have to enter trade-offs, etc. And you have to choose a specific definition of equity. So all of these modelizations can also give rise to algorithmic discrimination. And then, of course, you have the application of the algorithmic recommendation. So this interaction between the human and the machine is also a place where discrimination can take place. For instance, it's been proven that human operators of algorithmic decision-making systems interact in a differential way with the system. They are, for example, more likely to deviate from an algorithmic output in favor of a majority group and less likely to do so for a minority group. So you can see that here again, there is a space for discrimination. So risks are very big, and therefore anti-discrimination law has an important role to play. And now I'm looking at European Union equality law because it's very interesting, because it sets a harmonized framework for the 27 member states. But it's important to know that this regulatory framework only sets minimum obligations. So every EU country is free to go beyond these obligations, but now I'm just analyzing the minimum requirements that apply across the entire EU. And one of the biggest problems is one of scope, of course, because EU anti-discrimination law only prohibits 6 grounds of discrimination, and these are gender and sex, race and ethnic origin, age, disability, sexual orientation, religion, or belief. So that means that if discrimination takes place on any other category, like profiling data, whatever sports you do, or your health data, that potentially escapes the scope of the law prima facie. So the second problem with the scope is that the coverage of anti-discrimination law is also fragmentary. So, for example, if race and sex are quite well protected, the rest of the grounds is only protected in the area of employment. So not in the area of goods and services, for example. And that makes the protection quite patchy. In addition to that, there's a number of exceptions. So even gender equality, for instance, that's quite well protected, quite widely protected in terms of material scope. there are a number of problematic exceptions, for example, in advertising and in education. So a consensus is emerging that EU anti-discrimination law is too patchy to adequately tackle algorithmic discrimination, and in particular, beyond the scope issues that I just talked about, in particular in relation to the categories, the concepts and the categories that it proposes in order to capture discrimination. And in the reminder of this presentation, I'll give you 3 examples of these frictions between the way the regulatory framework is spelled out and how AI-driven discrimination takes place. And to start with, I wanted to show you this video, but I think you can just look at it, you can just watch it yourself. It's a video produced by a researcher at MIT, and I'm happy to give you the link after the presentation if you're interested. And it speaks to the first problem that I wanted to highlight, which is intersectional discrimination. So on the one hand, we have a regulatory framework that protects from discrimination based on single grounds of discrimination. So either gender discrimination or race discrimination or age discrimination, etc. On the other hand, we know that discrimination doesn't happen on the basis of single discrete categories, but it can combine them. It can be very complex. And that's called intersectional discrimination. So for instance, discriminatory stereotypes that target Black women and women of color in general are not only discrimination based on race or discrimination based on sex, but they really combine these 2 categories in a specific way. And it's been argued that EU anti-discrimination law is not very well equipped to deal with that kind of discrimination. Now, the problem is that with big data and granular profiling, algorithms are very likely to perform intersectional types of discrimination. So now we have a mismatch between the forms of discrimination that are produced by AI and the way the regulatory framework addresses discrimination. And the problem is that intersectional discrimination is actually already very pervasive in society, but since it's not legally recognized, it's not very visible. And because of feedback loops and because of that increased potentiality for granular profiling, we might have a risk that intersectional discrimination increases even more than it is, but at the same time remains invisible. So for example, just to give you a very concrete example, in our facial recognition example, it can be that if you're the designer of a machine learning algorithm, or if you're a data scientist, you will look for economically efficient ways to train your algorithm. So you might look for data that's already publicly available. And a way to do that is, for example, to take public assets of face image data that's publicly available, like the members of your national parliament, for instance. Well, the fact is that if you take that kind of data set, you already insert a bias in the machine learning algorithm, because that data set is very likely to underrepresent Black women's faces, just because intersectional minorities have less access to participation, to the public sphere, etc. So you end up reproducing patterns of discrimination that are already very pervasive in society. And I told you that the law is not very good at redressing intersectional discrimination, and I just wanted to give you an example of that. And this example is a case that's been decided in 2016 by the Court of Justice of the European Union, and it's called Paris. It was a case where the applicant had claimed discrimination based on age and sexual orientation in relation to specific pension-related benefits. And there, the Court of Justice said, well, there is no new category of discrimination that results from the combination of more than one grounds, such as sexual orientation and age, that may be found to exist where discrimination on the basis of those grounds taken in isolation has not been established. In other words, if discrimination based on age and discrimination based on sexual orientation cannot be proven in isolation, in separation, then there can be no combined discrimination. So that point really defeats the reality of intersectional discrimination that takes place on the basis of combined systems of inequality. So this is the first friction, and then a second friction is that of proxy discrimination. So we know that machine learning algorithms are trained to recognize patterns in large data sets. So the fact is that even if you would remove protected categories like gender, like race, like age, etc., your algorithm would not be prevented from discriminating on the basis of these categories. This is because the machine will still be able to identify related patterns through correlated variables, and therefore indirectly discriminate based on these criteria. So, for example, an algorithm was used by a specific workplace to predict which employees should be given a tenure track position, and the algorithm used as a predictor the distance between the workplace and an employee's place of residence. So at first sight, this seems to be a neutral area. It doesn't speak to any protected ground, that distance between work and home. But in fact, the users of that algorithm discovered that the algorithm was able to infer ethnic membership based on zip code data, so based on that place of residence. So the algorithm was in fact discriminatory, but that was proxy discrimination. So it used that residential data to discriminate based on ethnic origin. Other examples that can take place are, for example, discrimination based on sports data, which speaks to whether you're healthy or not. And that can influence the price you pay for credits or the price you pay for insurance, etc. Then the movies you watch on Netflix say a lot about your age, about your cultural affiliation, maybe also about your ethnic background, etc. So that kind of proxy discrimination is difficult to tackle in the framework that is laid out by EU anti-discrimination law. And why is that? It's because non-discrimination law has basically two categories. On the one hand, differential treatment, that is direct discrimination. So that is discrimination, it's basically treating someone differently because of a protected ground. So on grounds of disability, on grounds of age, on grounds of gender, etc. So you have that causality relationship between the protected ground and the differential treatment. So for example, an employee dismisses an employee because of her disability, for example. And then we have a second category, and that's indirect discrimination. And indirect discrimination is basically when a measure that's neutral, so for example, a measure that is based on your place of residence, it's neutral towards a protected ground, it doesn't speak to any protected characteristic in EU anti-discrimination law, but that neutral measure has a disproportionate disadvantage to a protected group. So treating someone differently based on the place of residence can discriminate indirectly against a specific ethnic group, and that is a protected characteristic under EU anti-discrimination law, so this is likely to qualify as indirect discrimination. The problem is that direct discrimination cannot be justified, or it can be justified on a very limited number of grounds, so the regime is much stricter. Indirect discrimination, on the other hand, can be justified on a much wider basis. So a defendant is able to say, for instance, well, yes, this is indirectly discriminatory, but I have a legitimate aim, and as long as this is legitimate and the measure passes the proportionality test, so in terms of whether the measure is objective and appropriate and whether the measure is necessary, then indirect discrimination can be justified. So the regime is much less strict. Now, how does that capture proxy discrimination? Well, proxy discrimination, in fact, is very unlikely to fall in the category of direct discrimination because it does not take place on grounds of a protected characteristic. It takes place on correlated variables. So residence that correlates with ethnic origin. So it's more likely to fall in the category of indirect discrimination. That is problematic because the number of justifications is much wider. Now, the Court of Justice has said in a series of cases, actually, for example, in DECA, that discrimination that takes place on a characteristic that displays an inseparable link to a protected ground is still likely, is still going to be captured by the notion of direct discrimination. So in DECA, we had the differential treatment of an employee based on her pregnancy. And the court said, yes, this is pregnancy and this is not directly sex, but this is an inseparable characteristic. It has an inseparable link to gender and sex. So this is direct sex discrimination. Now, on that basis, we might think that the courts would treat certain forms of proxy discrimination, of algorithmic discrimination, as direct discrimination. But again, this is uncertain because in later cases, like Jiske Finance, for instance, the court said that some data related to birth and last name did not display a direct or inextricable link to ethnic origin. So it's uncertain how strong that link between the proxy and the protected characteristic should be for algorithmic proxy discrimination to qualify as direct discrimination and therefore be subjected to a regime of justifications that is stricter. So there again, there is an uncertainty and a likeliness that algorithmic discrimination is not very well captured by the legal framework in place. Now, a last and third friction that I wanted to speak about is the notion of emergent discrimination. So we know that in the same way as you, when you go online, might rate a restaurant on Yelp, for example, algorithms perform a form of social sorting on us, and that relies on our behavioral data. For example, whatever we eat, whatever we sleep, whatever sports we do, our sleeping habits, our hygiene habits, all of that behavioral data can be used to also rate us. And that rating is used for commercial purposes. For example, that might influence the price you pay online, but that might also influence your access to certain types of advertising, whatever you see online, etc. To give you a very concrete example, if you do sports and you use an app like Fitbit, an algorithm is likely to rank you as healthier, and so you are less risky for an insurance policy, so you might obtain the policy at a lesser price, for example. So we can see that there are new patterns of systemic discrimination that can emerge based on aggregated social sorting that is performed by profiling and predictive analytics algorithms. And in other terms, that could lead to pervasive socioeconomic consequences for social groups that are not protected under EU equality law. If you think about Virginia Eubank's book, for example, Automating Inequality, you can see that your socioeconomic status or people's socioeconomic status is used by algorithms to give them access to certain benefits, to certain systems, and to, on the other hand, exclude them from these systems and benefits. And so we can imagine, for example, that discrimination could be emerging based on socioeconomic status, but also dominant body norms. So whether your weight corresponds to the norm, or your antisocial behavior, like the social sorting system in China, or even your capitalistic versus anti-capitalistic behavior. So whether you're someone who consumes in a way that reflects the norm, or whether you display an anti-capitalistic behavior. All of this data could give rise to new patterns of discrimination. That is, you might be subjected to different choices, patterns of inclusion and exclusion, prices, etc., online based on algorithmic analysis. And the problem is that that will not be captured by the regulatory framework, because in EU law, Article 19 of the Treaty on the Functioning of the EU sets an exhaustive list of protected grounds. So these are the 6 that I already mentioned: sex, race, age, sexual orientation, disability, religion, or belief. And that is it. So that list is not flexible. It's finished, it's exhaustive. And that means that potentially other emerging patterns of discrimination based on algorithmic analysis are not included. Now, there might be a way out in the form of Article 21 of the Charter, which is open-ended. So it provides for more criteria. I think there are around 15, but it's also open-ended. So potentially the court could say, like the European Court of Human Rights based on Article 14 of the Convention, the Court of Justice could say, based on Article 21 of the Charter, we might find new grounds of discrimination which are not explicitly listed, but that are relevant in the context of algorithmic discrimination. Now, 2 problems with that. First, the Charter is only applicable whenever member states are implementing EU law, so the scope is constrained, is limited. And second, in other case law, for example, in FOA, the court said that the Charter cannot be used to extend, by analogy, the framework of protection that is set by EU secondary law, so by the directives. So that possibility is limited. Now, to conclude, there's also a series of procedural challenges in algorithmic discrimination. And that is that you might not even be aware that you're discriminated by algorithms, because what you see online is already tailored to you. So you're sort of trapped inside your own online reality because of algorithmic personalization. In addition to that, it might be really difficult to bring an evidence or to bring prima facie evidence of algorithmic discrimination to a court of justice or a tribunal, because algorithms are black boxes. So they are not transparent. There are no standard explainability requirements as of now, and they can also be opaque, and protected by trade secrets. A series of other challenges concerns responsibility and liability. So who is to be held responsible or liable for algorithmic discrimination? Is it data scientists? Is it designers of algorithms? Is it end users, etc.? So that complexifies the question even further. Now, ways forward, I'm not going to dig too deep into that, because Alba's presentation is going to cover this. But we have anti-discrimination on the one hand, and I would argue that what we need is a purposive interpretation of EU anti-discrimination law in order to tackle algorithmic discrimination. We have the GDPR, and we have the new AI Act that has just been proposed by the Commission, which proposes a risk-based approach to algorithms on human rights. So to conclude, the distribution of algorithmic visibility mirrors that of the power of this definition. So that is, algorithms in fact reproduce patterns of power distribution that are at stake already in society, and they amplify them further. So what we need is a robust legal framework that can tackle that, because otherwise we're going to face human challenges that will be massive. And what I would argue is that we need a transformative approach. So if we adopt a neutral approach, we're just going to reproduce the discriminatory status quo, which is at stake in society. So what we need, in fact, is not only a human-centered AI paradigm. We need a social justice-centered AI paradigm, one which makes use of, for example, positive action, transformative, anti-stereotyping approaches in order to tackle algorithmic discrimination. And with this, I conclude by thanking you for listening to my talk.
So thank you very much, Raphael, for your very interesting presentation. Now we have a few minutes, I guess, for questions. If somebody in the public wants to pose a question. Does anybody have any question? No? If not, I have a question myself. No, first Andres. Andres has a question for you.
A very quick question, because after your wonderful presentation, my thoughts were that with all those risks that you have explained, we have also some opportunities, because you explained wonderfully how pervasive discrimination is in our societies, and how difficult it is to see it and to discover it in some cases, for instance, intersectional, cross-section discrimination. So maybe with artificial intelligence and algorithms, we have an opportunity to discover how it works, because the positive thing about algorithms and artificial intelligence is that we have to program them. We have to introduce all the inputs, as you explained, so we can track them, we can list them, we can try to understand them in a better way, because the algorithm, the program, is going to produce an outcome after what we feed to them. So maybe there's also the opportunity to discover how discrimination works in our society, not in the digital society, but in the previous society. But in order to do that, in order to achieve that, maybe we have to change the rules. For instance, we need absolute transparency about how these algorithms are working, in order to produce the benefits that we can extract from them. That would be my question. And many thanks for the speech.
Yeah, this is an excellent question. This is a point that I didn't mention so much in my presentation, but if you're interested, we with Janneke Gerards, we produced a report for the European Commission on this topic, and we have an entire chapter dedicated to opportunities. And I would argue this is a fundamental point. Following up on the last argument that I displayed in the conclusion, the one about transformative equality. What I would argue is, in order to turn these algorithms into opportunities, as you rightly say, which they also are, what we need is basically to, as you also said, to change the rules. So by introducing, for example, positive action in algorithms, we might also transform them into tools that can work for us and to the benefits of a more equal society. Other examples of opportunities would be when algorithms are used in order to audit other algorithms, or a specific to conduct a specific impact assessment, for example, to identify discrimination. So they can be used in a number of ways as opportunities and to benefits that fundamental right of or fundamental right to equality that is inscribed not only in the Charter but also in the treaties and in EU secondary law. So absolutely.